Hello and welcome to today's session. Today I want to talk about the rationale for affirmative action being overturned by the Supreme Court of the United States. So this is an informational perspective on the pros and cons of affirmative action being overturned, as well as the history of affirmative action in the American society over the past 4 to 5 decades. Some Americans believe that discrimination is a thing of the past. However, others either see it, hear about it, or experience it on a regular basis, at least in our society, in our neighborhoods. So the concern over the past few years has been that since the Supreme Court of the United States is a little bit more conservative nowadays, that they would actually ban the use of race-based affirmative action in the U.S. American education system. And this has led to some divisions among experts as well as people in society in general. Obviously, divisiveness is not anything new because over the past few decades, we've been hearing a lot of discussion, concern, and some rhetoric as well. As a matter of fact, if we go back to the 1990s during the former President Bill Clinton administration, the labor secretary at that time, Robert Reich, mentioned that no longer are Americans rising and falling together as if in one large national boat. We are increasingly in different, smaller boats. As part of our discussion today, we will talk about how race-based affirmative action has been used in the American education system over the past 4 or 5 decades. The divisiveness of our society is very apparent in the headlines that you see every single day on the news. As a matter of fact, you recall the fact that the Tennessee State House removed 2 male lawmakers over gun control protests, but spared the female protester. And many believe that the 2 lawmakers were removed because of their skin color, because of their race. Recently saw another case where a 12-year-old Black boy was arrested at gunpoint because of a mistaken identity while he was taken out of the trash. He was released a few minutes later, but nonetheless, a 12-year-old being arrested must be a shocking experience for a young teenager. Additionally, we saw the case of the 6 white former police officers, some of whom called themselves the Goon Squad, pleading guilty to torturing 2 Black men. As if torturing was not enough, one of these Black men were actually shot in the mouth, so he nearly died. In this case, the 2 Black victims were Michael Jenkins and Eddie Parker. They alleged in a lawsuit that the ex-officers' conduct was motivated by the color of their skin. We also saw the case of a young teenager by the name of Ralph who went to a neighborhood that he was not familiar with to pick up his 2 young siblings, but he rang the wrong doorbell. And the man behind the door, who happened to be white, shot him once from behind the door and a second time while he was on the ground. This incident caused the president of NAACP to issue a statement saying that tonight, millions of Black parents across America are going to have the talk again. This time adding another item to the list: don't ring the wrong doorbell. So this divisiveness does not stay in society. It seems to come with us in the workplace, which impacts teams of people in different organizations, different departments, different institutions of higher education. As a matter of fact, one study shows that 42% of workers in America believe that their companies or their organizations' diversity, equity, and inclusion programs are somewhat divisive. So the question before the Supreme Court is race-based affirmative action in college admission legal? More specifically, is the admissions process used by Harvard University and the University of North Carolina, or UNC, lawful under the Equal Protection Clause of the 14th Amendment? In this case, which was decided on June 29, 2023, there were 6 Supreme Court members who concurred with the majority opinion that it is unconstitutional to use race-based college admission systems. However, 3 Supreme Court judges were in opposition and stated their views as well. Race-based affirmative action in college admission is now banned. And so universities can no longer use race as a main criteria to accept students into their institutions. Why did the Supreme Court members overturn race-based affirmative action? It makes you think, especially when one of the Supreme Court members who agrees with the majority opinion happens to be a Black American. So what would make him actually go against affirmative action criteria that has been used in the university system? Well, the Supreme Court justices argued that it is all based on the 14th Amendment Equal Protection Clause, which states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law. Justice Clarence Thomas explained that college admission has become a zero-sum game, since Asian students tend to suffer because of an outdated overcorrection, which stems from the era of Jim Crow laws in the 1940s, 50s, and 60s. Justice Thomas says that today's youth do not have to and should not shoulder the moral debts of their ancestors. Justice Thomas concludes by saying that we must adhere to the promise of equality under the law declared by the Declaration of Independence and codified by the 14th Amendment. And Justice Brett Kavanaugh emphasized that a core purpose of the 14th Amendment was to do away with all governmentally imposed discrimination based on race. Additionally, Justice Neil Gorsuch wrote that today the court holds that Equal Protection Clause of the 14th Amendment does not tolerate this practice of race-based admission in college institutions. I write to emphasize that Title VI of the Civil Rights Act of 1964 does not either. So historical race-based affirmative action in cases include cases like Alan Bach in 1978, Barbara Grutter of 2003, and Abigail Noel Fisher, which was decided in 2013 as well as in 2016. These are cases where affirmative action in college admission systems have been allowed and deemed as constitutional given certain criteria. Alan Bach sued the University of California, Davis Medical School, claiming that he had suffered unfair reverse discrimination because of his race, because he was a white man. In Bach's case, which included the University of California, it was a landmark decision by the Supreme Court, which involved a dispute of whether preferential treatment for minorities could actually reduce educational opportunities for white applicants without violating the Constitution. So Alan Bach had applied to the medical school twice and denied admission. And he cited evidence that his grades and actually test scores surpassed those of some minority students who had been accepted for admission in the medical school. So he claimed that he had actually suffered unfair reverse discrimination because he was white, because of his skin color, which he argued was contrary to the Civil Rights Act of 1964, as well as the Equal Protection Clause of the U.S. Constitution's 14th Amendment. In Bach's case, the Supreme Court did agree that the university's use of strict racial quota was unconstitutional back in 1978, and the Supreme Court ordered the university to accept Alan Bach as one of their students. At the meantime, SCOTUS concluded that race actually could be used as one criterion in the admission systems of institutions of higher education. However, racial quota was considered to be unconstitutional. So it was in 1978 when the ruling of Bach by the Supreme Court actually legalized the use of affirmative action in college admission programs. In the Bach case, the Supreme Court of the United States affirmed that accepting minority applicants to affirmative action programs where race is one of several factors is actually constitutional under certain circumstances. However, the Supreme Court also mentioned that the use of racial quotas was deemed unconstitutional. And Barbara Grutter sued the University of Michigan's law school, again claiming that she was denied admission simply because of her race, being a white woman. In 1997, Barbara Grutter was a resident of Michigan. So she applied to the University of Michigan Law School, but she was denied admission. And she believed that it was because she was a white female. The law school admits to using race as a factor in making admission decisions because it serves a compelling interest in achieving diversity among their student population. So she sued the university. Eventually, the appellate court took the case and they rejected the district court's finding that the law school's critical mass was the functional equivalent of a quota. And as you recall, a quota system was deemed unconstitutional in the Alan Bach case in 1978. So eventually the case went to the Supreme Court. So the Supreme Court had to answer the question of, does the University of Michigan Law School's use of racial preferences in student admissions violate the Equal Protection Clause of the 14th Amendment or Title VI of the Civil Rights Act of 1964? The answer by SCOTUS was no. According to Justice Sandra Day O'Connor, the court held that the Equal Protection Clause does not prohibit the law school's narrowly tailored use of race in admission systems or decisions to further a compelling interest in obtaining the educational benefits that flow from a diverse student body at the institution. The court reasoned that because the law school conducts highly individualized review of each applicant, no acceptance or rejection is based automatically on a variable such as race, and that this process does ensure that all factors that can contribute to diversity are meaningfully considered alongside race. So in other words, it's a holistic process, and race is just one factor in the admission system. And Justice O'Connor wrote that in the context of its individualized inquiry into the possible diversity contributions of all applicants, the law school's race-conscious admissions program does not unduly harm non-minority applicants in the admission system process at the University of Michigan School of Law. In the Barbara Grutter case, the Supreme Court affirmed that race-based admission must have reasonable durational limits, reasonable durational limits in any deviation from the norm of equal treatment must be a temporary matter. In Abigail, Noel Fisher sued the University of Texas at Austin since she was denied admission, alleging that the university had discriminated against her based on race in violation of the Equal Protection Clause of the 14th Amendment. In the Fisher case, the Supreme Court affirmed that affirmative action must satisfy the burden of strict scrutiny where the justification in the duration of the program is limited to enroll a critical mass of certain minority students. So the court 2 times reaffirmed that a limited use of race in college admissions is constitutionally permissible if it satisfies strict scrutiny. In the Fisher case, there were 2 plaintiffs, Abigail Noel Fisher and Rachel Moulter Michaelowitz. They both applied to the University of Texas at Austin in 2008, were denied admission. These 2 women, who happened to be white, they filed a suit alleging that the university had discriminated against them on the basis of their skin color or their race in violation of the Equal Protection Clause of the 14th Amendment. The case ruled that strict scrutiny should be applied to determine the constitutionality of the university's race-conscious admissions policy. So in June of 2013, the Supreme Court ruled that the Fifth Circuit Court had failed to apply the strict scrutiny to the university's race-conscious admission policy and sent the case back to the Fifth Circuit Court. So in November of that year, the Circuit Court heard oral arguments from both sides. In their questions during the arguments, judges focused on the way the university defined critical mass, as well as past attempts the university had made to increase minority enrollment in their student body. And months later, during July of 2014, the Fifth Circuit Court announced its decision in favor of University of Texas, Austin. The majority wrote that it is equally settled that universities may use race as part of a holistic admissions program where it cannot otherwise achieve diversity through any other means. Fisher then filed a petition of certiorari to the Supreme Court. So in other words, the higher court has to look at this decision and review it, and the Supreme Court affirmed the decision. With regards to the strict scrutiny principle in the US constitutional law, when a law actually infringes upon a fundamental constitutional right, the court may apply the concept of strict scrutiny standard. The concept of strict scrutiny holds the challenge law as presumptively invalid unless the government can demonstrate that the law or regulation is actually necessary to achieve a compelling state interest at a given time. So the government must also demonstrate that the law is narrowly tailored to achieve the compelling purpose in that it uses the least restrictive means to achieve this compelling state interest. Now, if the government fails to meet this standard, it will result in striking the law as unconstitutional. So these standards are actually applied to all statutes and government action at all levels of the government within the United States. So we can summarize that education institutions that did use race-based affirmative action in the past had met at least one or more of several criteria, such as the fact that race was one of several factors being used at higher education institutions, or that there were reasonable durational limits in the fact that it was temporary and it met the burden of strict scrutiny to enroll a critical mass of certain minority students. So it's been said that if things go wrong, don't go with them. This is why some Supreme Court justices actually disagree with the majority opinion. As a matter of fact, Justice Sonia Sotomayor, in her dissent, disagreed with the concurrent opinion of the majority by saying that the 14th Amendment does not impose a blanket ban on race-conscious policies, and that the Equal Protection Clause permits consideration of race to achieve its specific goal. At the meantime, some experts like Dr. Roosevelt Thomas or Justice Clarence Thomas believe that affirmative action is a red flag to every worker who feels unfairly passed over, and it seems to be a stigma for those who appear to be the beneficiaries of its policies. Nonetheless, race is just one dimension of diversity. So colleges should continue to use all legal factors to diversify their student population and still achieve the benefits that are associated with a diverse student population in the classroom. We know that the likelihood of getting a job based on race and educational levels seem to go up when people are highly educated, and the gap between white, Black, and Latinos seem to be lessened when we have higher level of educations as majority or minority members of the American society. Recent data shows that there is a huge gap based on socioeconomic status of whites and Blacks for college enrollment. So we need to do more to provide opportunities for all minorities to have equal access to higher education. Otherwise, unfortunately, the disparities will continue. As Justice Ketanji Brown Jackson explains, the history of the American society shows that race-based gaps that first developed centuries ago are echoes from the past that still exist today. She explains that in 2019, Black families' median wealth was around $24,000 annually, where it was 8 times as much for white families. During the same year, the median income for a Black household was around $45,000, but it was $76,000 for white households and $98,000 for Asian households. So we all know that American children in today's environment do not all have equal access to modern technology, to modern education, and to social networks. That's why it's so important to make sure we offer access to all of our children to primary education and higher education so they can be competitive future leaders for tomorrow. Without accessibility and fairness for everyone in society, inequality and inequity will continue to divide us into haves and have-nots. And obviously, that's not a society that will make us competitive in the future. Of course, the problem is very complex, and we may not always comprehend or understand all the facts. But even when we don't have an idea of what the solution is, we shouldn't be a problem. We can always try to help by supporting the facts as we see it, by supporting the reality that is reported by our colleagues or by others in society. The fact is that those who understand unite everyone. Others sometimes perpetuate animosity and divisiveness. Let us be part of the solution and not the problem. When you know the reality and when you know the facts, it is important to speak up. Otherwise, don't be part of the problem. In those cases, silence can be golden, as emphasized by the former champ, Muhammad Ali. Audre Lorde mentioned that it is not our differences that divide us. It is our inability to recognize, to accept, and to celebrate those differences. We should recognize, we should accept, and we should celebrate our differences so it can become a source of synergy and competitiveness for our departments, for our institutions, for our nations. Albert Einstein mentioned that the significant problems we face cannot be solved at the same level of thinking we were at when we created them. Therefore, we have to think through new paradigms, different processes, admit the reality of the modern times, and then provide solutions that actually solve the problem as quickly and as efficiently as possible. We all can be part of the solution by being inclusive advocates of fairness and equality for all of our future. I wish you success individually and as an institution. As the quote next to me says, success is getting what you want, and happiness is wanting what you get. If you do what is right for you, for your colleagues, and for your community regarding equity, inclusion, and diversity and fairness for all, you will be able to not only be successful, but you will be happy and can sleep well every single night. Be an inclusive leader, be an inclusive professional. Thank you for listening to this presentation, and I wish you great success in being an inclusive leader in your organization and in your community. Good luck.